of this formality checks, the registry will now cause an instrument called an acknowledgement letter to be issued to you for the online filing, as the name suggests. Almost automatically, once you've complied with this one, there and then, as you are even filing the application, you will be able to also generate your own acknowledgement letter. While when it is for the manual, as the name suggests, of course, it will take some processes. In essence, confirmation of the payment, because of course your application paper will come alongside probably maybe the evidence of payment in the bank and things like that. So it will undergo all those processes before, again, manually we check on all the formalities. Once it is okay, automatically you will now be issued with an acknowledgement letter, which is more or less a hard copy for reasons that you are applying via the manual system. The next and most important stage in the application filing stage, next one is what is called the substantive examination. So yes, you have filed the application papers. Yes, you've gotten the acknowledgement letter. Of course, even in the wordings of the acknowledgement letter, clearly you will have read that we are more or less saying your application filed on so date has been given so number, and it is receiving attention, and you'll be communicated. So on the substantive examination stage now, we have a pool of examiners whose job it is to exclusively examine every such application you filed vis-a-vis the requirements of the law as to, for instance, one, whether is it even a mark that is registrable? If the answer is yes, is it available? So having satisfied with several of these answers, then of course, if their finding is in the positive, you will now be issued with what is called an acceptance letter, which is more or less a provisional approval. Emphasis, provisional approval. Where if on the other hand, however, your mark has fallen short of maybe the requirements of the law, you will now be issued with an instrument called refusal letter, wherein, of course, the reasons for the refusal will be clearly stated therein. And that will be it for purposes of at least the result of the application file. In other words, whether it is approved or it is not approved. Then the next stage now is, from our own end at the registry here, that your mark, if approved, it will now be published in what is called a trademark journal, which is an in-house periodic publication of the trademark registry. And of course, when we say journal, I mean, it is very clear. The essence of that is to statutorily provide a window, usually 2 months, as prescribed by the law, to allow for the public to have the privilege of knowing that such an application has been filed for registration as a trademark before the registry. And we, of course, we oblige the public with the particulars of that application. For instance, whether the application is only just a word mark, or maybe it has some logo accompanying it and the likes. And of course, since it is a publication to the public, and you have 2 months window or grace period, any member of the public now, whether from within in Nigeria here or from abroad, can write to object to you being given permission to go ahead with the registration of that mark. Take note that at this stage, we're dealing with your application is more or less is a pending application in the sense that if you had what I said earlier, what you had with the acceptance letter is a provisional approval. So in other words, at this publication stage, Sorry, are you hearing me? Hello?
Yes, yes, we can hear you very clear.
I'm
Thank you.
getting some interruption there. Are you hearing me?
Yes, we can hear you.
Okay. So the publication stage. So at the expiration of the 2 months, the registry will now collect all such objections filed in respect of the respective applications that were published in that particular edition of the journal. Of course, courtesy demands if somebody is complaining against you, you ought to be put in the know as to what those complaints were. So at the end of the 2 months, the registry will collect all such objections and now forward it to you via the address, the address you provided as at the time you are filing the application. And the essence of that is, again, to give you, the law makes it in such a way that it will now give you an opportunity, again, to now respond. Of course, it is more or less, everything is guided by the law. In essence, if you are given that opportunity also, there's a time frame within which you are allowed also to file your own counter response to the objection raised. So it involves a session of to and fro of exchange of processes between you, the applicant, and whoever is it that is opposing your mark for registration, until it will get to a stage whereby, assuming it is something that actually needs for the tribunal to decide, the tribunal will decide accordingly, and a considered ruling will be delivered. And once it is, for instance, if it is delivered in your favor, then you can now proceed to apply for issuance of a trademark certificate. And you can see at this stage now, this is the stage at which the hitherto acceptance letter you are holding, which is provisional, will now, legally speaking, be converted for you to now truly have the certificate, which legally speaking at this stage now confers on you as being the proprietor or the owner of such a mark. In the event, however, during the quasi-judicial proceedings that culminated in the tribunal sittings, in the event, however, maybe the finding is that, yes, your opponent, in other words, the person opposing your registration, has a valid point in objecting to your application. Of course, the tribunal will so rule. The tribunal will so rule. And if the tribunal so rule, then automatically your proposed pending application will now be stood down. You want to say something?
Yes, Mr. Yusufu, you know that you have only 20 minutes allotted to you, and it's very clear that you have so much to say.
Very well.
So,
I wish I was actually told of the minutes I was supposed to speak.
Yes. So it's we apologize for that, but I think in fairness to you that you have actually covered quite a great part of the topic you're speaking on, which is trademark, the need for registration, procedure, and requirements for registration for the creative industry. You have actually moved on to the dispute resolution aspect of it, the tribunal process and all of that. But of course, because of the way we have structured the conversation, I think it's important to break here and then take the 5 minutes for quick questions and then come back later when we have the general question. Meanwhile, you did mention that our very big boss, Dr. Yauri, is beside you. It would have been interesting to see his face, but if that is not possible, we totally understand. So at this point, we open the platform for questions. We have only 5 minutes to take a few questions so that Mr. Yusufu can respond before we move on to the next presenter. You can give us your questions in the chat bar. Anyone? Okay, so we will move on quickly to the next presentation because the presenter may have to leave us. So please prepare your questions. We can take it at the back of the next presentation. And the next presentation is by Ms. Laura Alakija Esquire, who is she's a commercial transactions and commercial dispute lawyer with specialties in intellectual property law. Her brief profile will go thus. She's the managing partner of Primera Africa Legal, a top-tier commercial law firm with offices in Lagos and Abuja, Nigeria. She has over 15 years experience in energy and natural resources, hospitality, construction and infrastructure, ICT, arbitration, and ADR. She is a fellow of the Chartered Institute of Arbitrators, an accredited mediator, and a certified online mediation expert. She's also an active member of the International Arbitration Community, currently serving as a member, ICC Africa Commission. Ladies and gentlemen, I present Ms. Laura Alakija.
Thank you very much for that kind introduction. I'm also grateful to the NCC/DRC for the opportunity to join this very important conversation. I'm happy to be speaking after Mr. Mohammed because he has laid some foundation which I do not have to go over and made my work somewhat easier. I'm also glad that Dr. Obegolu defined intellectual property, and Aisha, when she was doing her prologue, also mentioned a little bit about IP. So I will not go over definitions with you, and I'm sure that when you get to Folarin, he will take his time to break down everything that is happening in intellectual property law in Nigeria. My assignment this morning is to speak on how to safeguard intellectual property rights by leveraging on ADR as a mechanism to tackle the challenges that could come up in that space. In general, when you talk about intellectual property, as the word implies, I'm giving you a lawyer's description, so I will use the words to describe the words. It is property that is created using your intellect. And it has the word property in it because you can own it. The way you can own physical assets, you can own your intellectual asset. And depending on what the IP is, sometimes the right is automatic, like in copyrights. The right is vested in you the moment you impress that work in a media that another person can read it or access it. The other rights, like Mr. Mohammed mentioned in terms of trademark, you would need to register in order to be able to protect it against infringement from third parties. That applies to patents, trade secrets, domain names, and other classes of intellectual property. And typically the reason for protection of IP rights, as Aisha mentioned in her introduction, is because IP is in everything that we do. Everything has somebody's intellect that was applied in the creation. And in order to balance the interests of the creator and the users, you have IP protections. And because of that interaction, disputes could often arise based on use of IP. So even when
Laura, can you hear us? There seem to be some glitches with your network. Hello, Laura, can you hear us? Okay, so I can see that she is off, perhaps to reconnect again. But while we wait for her to come back, do we have any questions from the presentations that have been made so far? Perhaps we can have a short conversation around it before we get into, before we have Laura connect back with us. You can either put your question in the chat box, or you can maybe introduce yourself and ask your question. Aisha, is that okay? Okay, great. Aisha has a question.
No, I had a comment. Okay, so the participants, some of them have posted a few questions in the chat box, and I saw Binta also raising her hands. And you know, the interesting part is that Mr. Sadiq's presentation was so captivating and interesting, and as he was putting us through the steps. But of course, apologies, because, well, you know, in intellectual property, especially the procedures, there's so much that is to be learned and understood. So this workshop essentially is to kind of also give us like a wake-up call on what we need to go and learn. So I'm sure if you give Mr. Sadiq all day today, he can give you lectures on what you need. So, but then of course, we would ask if it is okay to share his presentation. So we would get your emails and share, and then also quickly try to address or ask him to address some of the questions there. There was something that I also wanted to ask, and I saw someone ask, he mentioned a prescribed fee that should go with the filing. So I wanted him to mention how much, what is the expected prescribed fees. And then also, there are a few questions. Okay, Binta asks, why are innovations not trademarked in Nigeria? And then there was a question on, does trademark only applies to goods, or is it inclusive of service? But then I can see someone has responded that it is also inclusive of service. Someone listed a few questions. Why can't we conduct a preliminary search via the online portal? Why do publications of registered trademarks take even 2 years to be published in the trademark journal? This does not usually bode well for me and my clients. Is there a reason these registered marks cannot be published via our online portal? Must it be registered in the trademark journal? Life has gone digital, and we all can agree. These are the person's questions. Uchenna something. Then
okay, Aisha.
Last one. Let me read the last one. In furtherance of Mr. David's presentation, he mentioned that after the substantive examination, an acknowledgement or refusal may be issued. So the question is, can the refusal letter be challenged by the applicant just as the acknowledgement can be opposed by an adverse party? So those are the questions. I can see Laura is back, so I don't know.
Exactly.
What do we do?
So,
should we call on Mr. Sadiq to note the questions, and we'll get back to him to respond to, and then allow Laura to continue?
Yes, I think it's best for Laura to complete her presentation, and then we attack the questions together. Laura.
Thank you.
Thank you very much. And I'm sorry for the interruption. I had to pray for someone to be bumped off so I could get back in, because I think we've hit the maximum number. Right. So I was saying that essentially, in terms of dispute resolution for intellectual property, the traditional channel is litigation. but with the recent trends, or as we experience exponential advancement in trade, in inventions, in the creative industry, in tech, in pretty much all facets of human existence, it has become increasingly difficult to manage litigation as the sole way of enforcing intellectual property rights. And maybe I should add that because also a lot of what we do now is online, and intellectual property rights often spread across jurisdictions, it's become imperative to also take a look at dispute resolution from the perspective of the international application of intellectual property rights. So litigation becomes a bit of a challenge. I will give you an example. If you have a trademark that is registered in one country, and there is an infringement of that trademark, well, it has to be registered in more than one country, actually. So maybe I should backtrack a little bit. Intellectual property rights are usually territorial. It means that you register them in one country, and if you're going to do business in another country, you will need to register them in that country. Now, the international framework for intellectual property is such that when there are international agreements on intellectual property that states are party to, it gives you some benefits or some rights, but you still have to register your intellectual property locally in another jurisdiction. So when there's an infringement of your rights in that location where you have registered your intellectual property, usually the channel will be to go to court. So I'll give you, for example, if you have infringements in 3 countries, it means you are going to 3 local courts to start proceedings to enforce your rights. These are different jurisdictions with different laws and different dispute resolution mechanisms. You might find yourself in a common law country and a civil law country. So even the rules that apply to proceedings are a bit different. So that can create a multiplicity of issues for someone who is trying to enforce their rights. It can be costly, it can be time consuming, because in different jurisdictions as well, the amount of time it takes to enforce a right through the court systems varies. So one person chasing all these avenues can face significant challenges. And perhaps the first benefit of looking to ADR for a solution, as we will see down the line, is the opportunity to handle these disputes slightly differently. Now, in terms of ADR, what we mean by ADR are avenues like arbitration or mediation or conciliation, and the different dispute resolution mechanisms that have increasingly become popular for intellectual property disputes, because they give a slightly different alternative to the court systems, to litigation. So if you are enforcing your intellectual property rights, especially for transnational disputes, you find that the first benefit you enjoy is that it gives you a single procedure for dispute resolution. That means even though you are looking at, if we are to use our scenario, violations in 3 countries, if it's by the same individual or the same entity, you can have a single arbitration to resolve that dispute and to be able to enforce the outcome of that resolution across the different jurisdictions. So if you go to arbitration, for instance, and you get an award, it is more likely than not that you'll be able to take that single award and enforce it across the different jurisdictions. The reason I say that is because usually for arbitration, there are uniform rules that most countries have adopted. So for instance, the UNCITRAL model law, which has rules for arbitration, most countries have enacted their arbitration laws in line with that model law. So the principle is pretty much similar or the same in most countries. And then we have the New York Convention, which is the Convention for Enforcement of Arbitral Awards, which allows enforcement of arbitral awards in all signatory countries, meaning that any country that is a signatory to the New York Convention, you can take your award and go and enforce it in that country without starting a fresh court proceeding, as would have been the case if you were going to the courts to enforce your rights in those multiple jurisdictions. Again, the New York Convention has over 160 signatories. So there are very few countries in the world that you would go with your arbitration agreement and not be able to enforce an intellectual property right. So obviously, the first benefit of relying on ADR as a means of protecting your intellectual property right is the single dispute resolution mechanism option. That option is also flexible. It is party driven. So parties can choose their forum, they can choose the rules, they can choose the arbitrator or the mediator, whatever the third party neutral is. This also means that apart from giving you a single procedure that you can rely on, it allows you to pick experts, because the courts traditionally may not have expertise to deal with the issues that you have to, that you are dealing with. For intellectual property rights, one of the more popular global organizations that users tend to turn to would be WIPO. I think Dr. Obegelu mentioned them in his presentation, would be the World Intellectual Property Organization, especially because they have a Center for Arbitration and Mediation, and they have experts in the respective fields that can either arbitrate or mediate the disputes. Also, there's the question of expediency. There's a question of confidentiality or privacy. We know that for court proceedings, everything you do in court is in the public domain. In the ADR track, you can opt for confidentiality and privacy so that you can preserve both the relationship and the rights. If you don't want your rights or the dispute that you have to be in the public domain, that private or confidential forum allows you to be able to do that. So those are some of the benefits of relying on ADR as a means of securing your intellectual property rights. This is in addition to the fact that being a collaborative process, it is possible to preserve the creative process while trying to settle this dispute. So it does not interrupt creativity. It sustains the innovation and creative process while parties are trying to resolve. And sometimes you do not even have to end or terminate the underlying contract simply because there's a dispute. You can resolve that dispute and continue with your business relationship. So in terms of safeguarding intellectual property rights, ADR is becoming the go-to mechanism for dispute resolution, and parties would choose arbitration or mediation or any of the other dispute resolution mechanisms based on their preferences, based on the nature of the dispute, based on the institution, for instance, if they're using an institution, and the sort of flexibility that affords them. And speaking of flexibility, I think perhaps one of the things I appreciate most about the use of ADR to preserve intellectual property rights is that there is no limit to how creative you can get with your choice of a dispute resolution mechanism. And I have seen all sorts of situations where parties will pick arbitration, will suspend proceedings and go to mediation and then come back or seek administrative interventions, especially in spaces like fintech, where things are happening very quickly and you need to quickly resolve the dispute so that parties can carry on with the transaction without any further delay. You find that in such instances, sometimes parties will get creative. They will use something like an administrative intervention. And by administrative intervention, I mean that they will work with a dispute resolution solution that is provided by the regulator within the industry. So that way the regulator, because you are responsible for that market and you understand the specific issues, and you can give specific directives that both parties will be satisfied with and apply, you can go straight to them for a resolution, as opposed to even convening a panel or trying to appoint a third party neutral to resolve the disputes between parties. I think that the final thing I will say on the subject before I allow other speakers to intervene is that as technology evolves and as we find ourselves that, operating in more and more of a virtual space, we will see that even for arbitration and ADR, there will be nuances that will come into the field, which maybe we are not seeing so much now. And there will be automatic dispute resolution mechanisms, which, parties can trigger without following the long procedure for appointment of third-party neutrals. And as that happens, you will find that flexibility is even more, cost reduction is even more, and expediency is even more. And my final is that the gains of using ADR to protect intellectual property rights, it also is able to ensure that parties maintain fair competition. I mean, well, this is a general benefit, but what we've seen with the use of ADR for protection of intellectual property rights is that, in general, it has helped to sort of shape that aspect of the protection of rights so that there is fair competition without putting some of the controversial issues in the public domain. So while the public sees that these multiple entities in that space are competing fairly, we do not see the underlying conversations or the underlying disputes that are creating a level playing ground so that one party does not outdo the other in terms of competitiveness and use of intellectual property rights. I will stop here for now and would be happy to answer one or two questions before I have to drop out. Thank you.
Yes, thank you very much, Ms. Laura Lakija. I think I should give you a round of applause myself. Thank you so much. Yeah, thank you, Mr. Folarin, for joining up as well. And also, Mr. Folarin, thank you for the great work you're doing in the chat bar over there, explaining things to our participants. Yes, I agree totally with you, Ms. Laura Lakija. Before, or rather in the past, you only had the one-way traffic of conflict or in dispute. It's either we deal or we don't deal. But I like the angle of bringing in the fintech aspect, where, for instance, if a vendor has issues with Paystack, for instance, and you have 5,000 transactions pending, you are not going to be talking about breaking the transaction, or you won't be saying we're not dealing anymore. No, you have to find a way, which I'm tempted to say that ADR is becoming the gray that is now between the black and white of dispute resolution, so that you can tidy up things. But I will leave all of that to our participants. So do we have questions for Laura? Can we quickly, I'm seeing some, someone says, at what point can an arbitrator rely on IP valuation report in claims? Is that clear to you, Laura?
I'm trying to understand the question.
Okay, let's see. We have a compliment. Beautiful presentation, Laura. Well done. Okay. Okay, so Mr. Folarin is throwing more light on that. He says an IP valuation report forms part of the evidence provided by
the parties.
By the parties. Okay,
absolutely.
Great.
So the direct answer to that question would be at the point where the party who is trying to establish that intellectual property rights introduces it in evidence. If they don't, the arbitrator is at liberty to request. Well, it depends, honestly. Sometimes that sort of direct request would amount to stepping or descending into the arena. So sometimes when you ask questions as an arbitrator, it suggests that you are tilting in one direction or the other. But typically, I would say when the party who needs to establish that introduces it into evidence. Hopefully that is during the exchange of pleadings and not after pleadings have closed, because you may not be able to introduce anything afterwards.
Fantastic presentation, Laura. Thank you for that. I think you just wrapped it up. I was going to also just add to what you said that, since, and I think it ties up with the question somebody asked earlier in the chat, that intellectual property, the property component, as Mr. Oga Sadiq said, actually speaks to the value of the IP. We talk about property because property has value. And the basis for arriving at a decision, in fact, the entire basis for any dispute really centers on the proprietary value of that intellectual property, right, or intellectual property asset that is in dispute. And so the best time for an arbitrator, to rely on a report would be at the point of taking evidence, as Laura said, because then the arbitrator then will still weigh the value of that report, because reports also, as we all know, come from one side. And so the question then will center on to what extent will the arbitrator believe the report that, that IP is valued at on the basis or at the amount that, that party claims, that the IP is worth. So a party can say, okay, if the issue is infringement, for example, this our brand is worth 10 million naira, and we have, a valuator, a valuer, or somebody in an industry. There's this very interesting case, the Marvin Gaye case, the Robin Thicke against Marvin Gaye case, where although that it was decided in court and not at arbitration, but the family, the Marvin Gaye estate, brought a music licensing expert who then gave evidence as to what the value of the work would have been had a license been entered into, and the jury relied on that in coming to the decision to, value it at about $5 million or so. So thank you, Laura, once again.
Okay, yes. Thank you, Mr. Folarinwa there for helping us out with this. Laura, there's a quick question for you. This is from Mr. Uchenna Mboji, and he's asking, thank you, Laura, for this presentation. I want to ask, is there any kind of membership on intellectual property arbitration one can join? If yes, what would it be? Or rather, what would it take to join SAME?
Well, I will start by mentioning NCC DRC. So maybe that question, you should tell people how to join you. Obviously, you can research WIPO online and also try to join the WIPO Arbitration and Mediation Center as a third-party neutral. As a third-party neutral, that would be my response. I think that should answer that question. So maybe at some point, you will let participants know how to join NCC DRC.
Definitely. Another one says, Mr. David Oguda, thank you so much for the very insightful presentation. Could you please recommend courses, programs where one can get more in-depth knowledge on the arbitration over IP issues? Okay, is that a no-brainer or what?
It is, but I mean, there are a number of institutions that you can look at for certifications, whether it is arbitration or intellectual property or both. And I will just repeat my answer to the last question. Obviously, NCC DRC can give you some education on the subject, and on a global level, you can check the World International Property Organization Arbitration and Mediation Center. Outside of those, there are a number of other arbitral institutions that provide basic training on the subject. I know that the Chartered Institute of Arbitrators does that. I know the International Chamber of Commerce also does that. Those are the places that you can look to for training and understanding, and you will find a lot of programs like these, webinars that you can attend. Some of them are even free. So you go and acquire this knowledge for free, then you turn around and bill your clients. It's fine.
Okay, interesting. Mr. Folarinwa.
There are only 100 people here, so.
Mr. Folarinwa, do you have
quote me to your clients?
supporting positions for that?
Folarin is muted.
Mr. Folarin, you're muted. You're muted.
You might
You're muted.
you might have to enable him to unmute himself.
Okay, yes, I think the host very rightly locked participants on muting themselves. So
Yes.
I agree with Laura. The IP Institute also does provide courses on but IP mediation, because let me take a branch away from Laura. Mediation really is where everybody tends to go these days. So IP arbitration is also a big deal. And I think the Federal High Court also has an ADR center as well. But of course, NCCDRC is your first port of call. And I know Uchenna Mboji. Uchenna Mboji is an IP, is a very notorious IP lawyer. So hi, Uchenna. But yes, I think WIPO, the challenge with WIPO, and WIPO does a very good job of this. I think the Copyright Commission also has a mediation center. Yes, I think they have a mediation center as well. So, but fantastic presentation, Laura, and great questions. Thank you very much, Neb.
Thank you very much. I am going to have to beg to take my exit. Before I do, I noticed one question in the comments that asked if IP can be jointly owned, copyright, if it can be jointly owned. Yes, it can. And it is automatic. So if two people create something, they immediately have copyright to it. I mean, if you're doing a piece, if it's a book or an art piece, I would recommend if both of you author it, both your names should be on it so that there's no quarrel as to we both wrote it, but it's only one name. If it's only one name we see on the book, you might have a problem trying to establish that I have copyright in this book. Those are my final words. Thank you again. And I'm sure that Folarin will give you far more detailed answers than I've been able to provide.
Okay, thank you very much, Laura. It was such a pleasure having you make presentations and take questions. Thank you so much. To enjoy the rest of the day. Thank you. So moving on, I'd like to inform the House that one of the presenters, Mr. Basil Udotai Esquire, who is a technology advisor and an ICT lawyer, is unavoidably absent. So he sent his apologies. According to our program, the next item is the panel discussion. The panel discussion, the topic is leveraging on ADR mechanisms to tackle challenges. No, not that, forgive me. The topic of the discussion is experience sharing and general discussions. And this is where we're supposed to have the celebrities, but I think there's been some issues with them joining because the platform is full. But of course, our very own Mr. Folarin Aluko is here with us. He's a member of the panel. Mr. Folarin, you're welcome. I saw Mr. Collins Nweke. Mr. Collins, can you let us know if you're still here? Mr. Collins, are you with us? And also, Ms. Binta Shuaibu, she was with us, but I can't see her anymore. So what I would say is, Mr. Folarin, can we proceed? Can you lead the session while we wait for your colleagues to join?
Fantastic. I'd be very happy to, and I should say a big thank you to the Nigerian Chamber of Commerce Dispute Resolution Center. I think somebody asked what NCCDRC means.
Yes, I was.
Yes, for putting this conversation together. And thank you, Nem, you're doing a fantastic job, both you and Aisha.
Sorry, please, I'm here. I was unable to unmute myself, but I'm here just to say I'm here. Collins Nweke.
Okay, please, Mr. Collins, can we see your face, please? It helps. Okay, so while you get that together, Mr. Folarin, I think you can proceed.
Yes, I was saying that both Mr. Mr. Sadiq, Mr. Yusufu, and Laura really set the stage, for, I think, a very robust conversation. Mr. Sadiq talked about trademarks and how, and the importance of trademarks to the creative industry. And really, at the end, in the general scheme of things, when one looks at the question of how do you protect brand value? How do you protect? We all know that the basis for protecting brand value, or the basis for protecting reputation, really centers around trademark law. And I think a good place to start the conversation from would be that there was something Laura said, about, and it has been echoed, throughout this conversation, that ADR is the go-to, is the go-to option now for resolving intellectual property disputes. And I would say yes. In fact, in certain countries, for example, in the United States of America, about 99.9%, maybe let's say about 95% of creative industry disputes are resolved by alternative dispute resolution. Whether it's a mediation or industry-based settlements, or business settlements, or conciliation or arbitration. These forms of dispute resolution are a much quicker and much more efficient way of resolving disputes, especially when you have disputes that are time sensitive. For example, I did some research some years ago into this issue of the resolution of movie name disputes. Recently, we had a huge row over the question of the name Domitila. The Domitila movie from the 90s, and then somebody registered a trademark, and thank God the registrar I believe is here. Someone applied for that trademark and it was denied, and all that. In the US, for example, they have a system of mediation, and you never hear about movie name disputes. And that mediation system ensures, confidentiality, so nobody knows who is arguing for what title. It ensures confidentiality. It ensures that studios are able to choose the names that they want to, produce for the titles for their work, and then move on once those names, have been agreed upon. And it allows for the creative part of the creative industry to actually be creative, and especially when you look at in the US, for example, and then Nigeria also. But when you look at in the US, the volume, I think about 10 years ago, 90% of movies, 90% of blockbusters that were produced in the world came from Hollywood. I think the number is much less now because we have more award-winning movies or blockbusters being produced from Bollywood, from Nollywood, and from other industries across the world. So ADR really is a sine qua non. And I think with regards to the Nigerian industry, the Nigerian creative industry, what I have found over the years is that the various industries already have some form of unstructured mediation, unstructured system by which disputes are resolved. Sometimes, especially if you look at, for example, with among comedians, when there have been a couple of disputes I've heard about, and many times, I don't know if I should mention that person's name, but we hear that, oh, this particular person, one of the richest men in Africa, will call XYZ comedians to his house and they will resolve the issue, among themselves. So that's an unstructured form of dispute resolution, and we find that, playing out in the Nigerian scene. I think one of the reasons why that tends to play out is because of what I would call the African concept of property, which is a communal one. As Africans, we hold property on a communal level or as a community. And even when our ancestors, pass on, we still believe that our ancestors, form part of that community. So, and if you notice, the world actually is moving in that direction. Now we have the concept of course, Creative Commons. You have all sorts of shared and you have GPU licenses, which are general public user licenses with regards to the software industry, and that has kind of boomed the fintech sector. So, you find that the world is moving towards a shared or communal concept of property, particularly intellectual property. And this conversation, could not have come at a more crucial or important time. I don't know. I don't want to hog up all the airspace, so I see Mr. Inter and Mr. Collins are here.
Yes. And thank you very much for mentioning Dangote without mentioning Dangote. So, so Mr. Collins Mweke, it's good to see you. Also, Ms. Binta Shuaibu, I can see you've reconnected back. So let's get a few. Let's hear from Mr. Collins Mweke.
Okay, thank you very much, and let me also use this opportunity to first of all thank the Nigerian Chamber of Commerce Dispute Resolution Center for putting this together. We are very happy to be part of this program. I mean, the Nigerian Copyright Commission is very happy to be part of this program. And as we know, from the copyright perspective, which is essentially dealing with the creative industries, we notice that it is observed that with increasing awareness of the commercial value of intellectual property-based products, managing relationship among the various players becomes more challenging by the day. While the interest group in the entertainment, in the creative industries, such as the artists, the performers, the writers, the dancers, the book authors, and all of that, while they are increasingly occupied with creative productions and the expectation of financial reward for use of their creations, it's known that users of entertainment products and services, in most cases, expect to use such products or services at little or no cost. And of course, the CMO, collective management organizations, are also interested, to ensure that users of entertainment products will obtain appropriate license for the use of their work. And of course, in that process, there are bound to be disputes among the different interest groups, hence the struggle with conflicting positions. And so for us, there are bound to be conflicts, in the how in the creation and the exploitation of creative works such as intellectual property protected works, because money is involved and a whole lot of other things involved. And of course, when such dispute, which is inevitable, of course, we know that the traditional method is to go to the court and seek for relief. But increasingly, it has been observed over the years that court has become more expensive, as it can also take a lot of time before you can get a judgment. And also, you are looking at a situation whereby, because of the sensitive nature of creative works, where, court process could easily, be a stumbling block to the creative process, which then requires for a quick solution, a faster way of resolving conflict. Found out that all of this put together, issue of expensive nature of litigation, issue of time, that is needed in some cases to get copyright protected works, through the processes of production and all of that. And of course, the issue of the technicality that is involved sometimes in these creative works, that sometimes even lawyers could struggle. Some lawyers, not all of them anyway, some lawyers could, some judges could struggle, to really understand the main issues. Because some industry practices and all of that are involved. So we found out that alternative dispute resolutions has become, something that is increasingly being embraced, not just in Nigeria, but across the world. And so the Nigerian Copyright Commission, and in its new Copyright Act, the Copyright Act 2022, that was signed into law just in 17th of March 2023. So that particular law provides for a dispute resolution panel to resolve disputes that are arising either from payment of royalties or from terms of license or for any other conflict or dispute that requires the determination by the commission. So the commission, has that power now to empanel a dispute resolution panel upon, a declaration of dispute, from either all or any of the parties. And of course, under the collective management organization, the new collective management organization, which has just been recently amended by the commission, it was also a clause also was provided to encourage, collective management organizations in their relationship with users of creative work of their members, to embrace the use of ADR also in settlement of disputes. So, having said that, the dispute may arise from contractual relationships or non-contractual relationship. And in terms of contractual relationship, we're talking about copyright contracts, contractual disputes. We're talking about licensing agreements. Talking about disputes from licensing agreement, dispute from payment of royalties, dispute from content distribution agreement, dispute from broadcasting agreements, and so on and so forth. And for the non-contractual contractual agreement, we are talking about dispute arising from copyright infringement, which is the unauthorized, use of copyright protected work by another person without recourse to the owner of the work. And so, copyright, as we know, is an exclusive right that is granted by law to owners of certain works to authorize to use or authorize another person to use that work in defined ways. And so, copyright also protects the copyright law protects investment in the field of creativity. It also incentivizes creativity, and of course, by the Universal Declaration of Human Rights, Article 72(2), it is stated that everyone has the right to the protection of the moral and material interest resulting from any scientific, literary, or artistic productions of which he is the author. So, the UDHR 1948.
Sorry, Mr. Collins Mweke, can you please unmute? Mr. Collins, can you hear us?
Okay. Sorry, I don't know how we went to, I was unmuted. Okay, can you hear me now?
Yes, I can hear you.
Hello?
Yes, please go ahead, sir.
So when the conflict arises as a result of infringement, the author of the work, have several options, which of course, like I said before, the first option is usually, which is the option that have been going on before is to go to court. But also, you can the owner of the work can also explore ADR, to explore the possibility of getting a faster settlement of the dispute without acting as a clog to the creative process. So I will stop there for now. And of course, sorry, at the international level, we also have the WIPO ADR Center, WIPO Alternative Dispute Resolution Center, which also offers, mediation, and whereby mediation, for instance, fails, where the settlement is unable to be achieved at mediation level, you can also go to arbitration, and also seek for expert determination. And of course, WIPO also have a domain name, what they call the domain name dispute resolution, which is basically targeted at resolving dispute that has to do with trademarks and of course domain name, dispute also. So having said that, I think I will stop here for now.
Okay.
And I'll be happy to keep in more things as time goes on.
Thank you very much, Mr. Collins Mweke. Like I said earlier, we're happy to see that Ms. Binta Shuaibu, the fashion entrepreneur and the CEO of Vintage Colette, is back with us. But most importantly, I would say that we should do our best to hold fast to our chairs, because I can see that Kanayo Okanayo has just joined us. I have no plans of disappearing from here, but Mr. Kanayo, can you please let us see you, please? Thank you so much for joining us.
Yeah. Good morning, everyone. I'm really. My apologies for joining a little late. I'm in the United States. I'm trying to wake up.
Oh, great. Oh, thank you so much.
So I can't, before you disappear, I can't show you my face. Also, don't take it that I have jackpot. No, I'm still, I'm just in the United States for some programs. Good morning, everyone.
All right.
Morning.
All right. So maybe, I think, Ms. Binta, are you still with us? Can you say a few words before we move to KOK?
Yeah. Hello, everyone. Can you hear me? Can you hear me?
Yes, and can we please see you? It was very interesting to see your double-breasted outfit, but now I can see you. And the headgear as well,
Oh, thank you. I'm due for another meeting at the moment.
Okay.
So, I may not be allowed to make that visual confirmation for now, but thank you for the outfit compliment.
Okay, you're welcome. You're welcome. So we can receive your contribution. We can have an audio. Let's get your inputs via audio.
Okay. So my own input as a fashion entrepreneur is began from an innovation I wanted to trademark 6 years ago. And Aisha is very aware of it because I even went to the Nigerian Bar Association office to find out if there are any details covering that. And I did go to Ministry of Trade and was told for me to trademark that innovation, it had to be a business name, cannot be an innovation, it should belong into patents or copyright. And copyrights are mostly for artists, for entertainers, and patents are for scientific innovation. This is a scientific innovation under the fashion industry that covers a whole wide range of the fashion value chain. But I was informed by the trademark office that I had to register it as a company, but it's not a company, it's an innovation under my own company. And in as much as trademark covers it as an umbrella, I tried to get it patented in the United States, of which I could have gone ahead to do, but because patents and copyrights have a lifespan compared to trademark that is trademarked for a whole lifespan or for as long as that company exists and it's been in use, there was a lot of conflict of what to do, where to do, and if I had registered it with the patent office in the United States as of then, I mean, this was 6 years ago, I would have had like 14 years left before that innovation is made public. And then I had not registered it in my home base. and then there will be a time lapse and difference here and there. I did consult with a lot of law firms in Lagos and even here in Abuja. No one could give me any definitive answer as to how I can trademark an innovation as a fashion entrepreneur in the fashion industry that can work for entire fashion value chain on a global level. And I don't want to take it to another country first. I would like to trademark it here, but you know, the information is very sketchy and no one seems to know what to do. So for me, that has been a major challenge, and to date, there hasn't been any upgrade or new information coming to light. And the trademarks are different in different parts of the world. In the US, the first person to make use of an innovation or something they want to trademark has all the rights. In China, it's different. It's the person who registers it first. But in Nigeria, I'm sure you would have to, of course, register it. We have trademarks that people would dare not to copy at all, you know. But in as much as we're trying to move forward globally, I think we should be open to bigger ideas. I did pose a question to Mr. Mohammed from Ministry of Trade, but I haven't gotten any answer back from him. And that was also part of the problem, getting to register it with the ministry. There was a lot of bureaucracy involved, and it was much easier to get a lawyer eventually to do that whole process, which was successful for my brand name. But for my innovation, nothing has come forth from that angle. So I don't know if there's anything new that any person in this panel can catch up on that, because mine is specific. The concentration, like I said, is on entertainers, literary world, and artists.
Thank you very much, Ms. Binta. It's a very interesting position that you have. Interestingly, again, I was in that position some 13 years ago when I was working on my intellectual property project called Idea Police. Funny enough, is the current director of the Trade Center, the current registrar of the Trademark and Patent Office, Mr. Yauri, that was with me through this process, and we have had to, I would say, grow, you know, over the years. So, but I think Mr. Folarin should react to that, and then we hear from Kanayo, then we come back to hear from the Mr. Yusufu. Folarin, please.
Okay.
Can we unmute Mr.
Sure.
Thank you very much. And fantastic. Thank you, Mr. Binta Shuaibu, for that, for sharing that experience. And I think it's actually a very common experience that many creators complain of. But before I go there, I was laughing. I had an interaction with Uchenna in the chat, and we talked about the ongoing. So we're talking about disputes. Disputes happen everywhere. Even in Hollywood, there's a dispute between the Writers Guild and producers. You know, and the subject matter of the dispute really is royalties from streaming, so residuals, royalties from streaming income, you know, from streaming income. And of course, we know that the streaming industry has really disrupted the entire broadcast and television industry, if you may. You know, and Uchenna mentioned something. He said streaming income, streaming royalties is the blood money of IP. And then somebody said something about blood money, where mentioning blood money, where Oga KOK is on the stream. So that's on a lighter note. You know, but I think that there's a huge misunderstanding generally about, in Nigeria, about what forms of intellectual property rights protect, different types of intellectual property. And the truth of the matter is that there's no, the what is referred to as the first intellectual property law, the Statute of Anne, was passed, which was enacted to protect literary works, or the copyright statute. It was enacted as a law that gave a monopoly, or that kind of granted monopolies. So, but it was enacted to protect literary works, and then today that the subject matter of that protection has expanded beyond literary works to performances, and all manner of works. And of course, the same thing goes for, you look at trademarks, you look at patents and industrial designs, and then other forms of intellectual property rights as well. We have you have trade secrets, you have the subset of patent law, these utility models, and so on and so forth. So that there are some forms publicity rights, which are image celebrities have. So if someone were to put Kanayo's picture on a movie poster, for example, the question will be, have they used his image in a way that that infringes on his image rights? So there are several ways that the law protects different forms of intellectual property. In this case, his intellectual property is his image, and so there's the general confusion as to which intellectual property rights protects different forms of intellectual property. Because the truth is, Nigerians are very creative. We're very creative people, but then, that general misunderstanding tends to affect, professionals. And it's one of the things that the IP Institute is very passionate about. And we've done a lot of work, and truly, I think Nigeria has come very far. One good thing to note is that the recently passed Copyright Act actually takes some of these realities into consideration. So it captures certain realities around, the digital economy. So creation of work online, in user-generated content and things like that. I would say that to kind of put all this together, because intellectual property is about property, there will definitely be disputes. And with Ms. Binta's situation had to do with issues around registration and protection. The interesting thing is that even in situations where, because somebody asked that question, where your work is not registered or your intellectual property asset is not necessarily registered, it doesn't mean automatically that the law doesn't protect that intellectual property right. It just means that, one may not have as much a level of protection depending on the type of intellectual property. For example, copyright in Nigeria is formality free, and registration is not a requirement for it to be valid, for validity. With regards to trademarks, however, an unregistered trademark owner cannot seek or cannot file an application for trademark infringement, cannot sue for trademark infringement. But that person still has a right to file an action under or to protection under the thought of passing off. So there are different levels of protection, and what that also means, ubi use ibi remedium, where there's a right, there's a remedy. So it means that there are several opportunities available for parties, for creators, for creatives to use the ADR process to actually get or extract value from, disputes that arise in the course of exploiting their works. And I think to wrap it up, I would piggyback to a question that Mr. Israel Usman, my Oga at the top, asked. And he asked just some things to consider when drafting a dispute resolution clause in a contract. I think the first thing to look at would be the type of intellectual property asset. So if it's a contract, maybe for the broadcast of a movie, you have to look at, what's the nature of the intellectual property asset. In the course of producing that movie, what other forms of intellectual property were used? So there must have been soundtracks. Was any artwork used? Was any sculpture used? All those things have to be put into consideration. when drafting dispute resolution clause. So the nature of the intellectual property asset, the fact of registration, whether there is any form of registration required. So if it's a brand, for example, let's say it's a franchise agreement, there's a huge question as to whether one should enter into a franchise with for an unregistered trademark or an unregistered brand. That's a big issue for determination. And thirdly, I think also importantly, the extent of disruption that any dispute will bring or will give to the services being enjoyed. For example, let's say somebody writes software code for a bank, for example, and licenses that software to the bank. And then tomorrow a dispute arises as to the ownership of that software, or as to, whether the licensing fees paid by the bank are sufficient. And the owner of the software, blocks the bank from accessing the software or locks the bank out of that software. There will be a huge disruption to their services. So one has to also look at what the nature of the disruption that access to that service will give. I think I mentioned one or two other things, and then of course, there's a business impact in that chart. So these are some things that one can consider when drafting a dispute resolution clause in an IP dispute resolution clause in a contract. I think I've tried to bring everything together in one piece.
Yes. Thank you. Yes. Thank you very much, Mr. Fulaiwa. I appreciate your contributions and explanations. I think at this point we should get a perspective from Kanayo Okanayo. Mr. Kanayo, are you ready to give us your perspective on the topic of discussion? Oh, yes.
Yes. Once again, good morning, everyone.
Good morning.
I'm quite delighted to be on this platform. I want to thank the last speaker, Mr. Aluko, for the points he made. Quite unfortunately, for those of us who have been active in the creative industry of Nollywood since 1992, it's been a run to and fro of our families asking us, are you sure you chose the right business? Because you never bring anything home. Most of my colleagues have been retired, even when they have not gotten to retirement age, due to non-protection of the intellectual properties of what they have had to create over the years. Sadly, the government agencies who are vested with this power of protection of the rights have not done any job, it's just on paper. I remember a story that happened when we were using, I think, VHS or after Umatic VHS and high definition for transmission. Then Alaba was a hub of marketing for the content we were generating. And somebody had infringed by mass producing the content of the then movie, and all the agency of government could do was go and bring him. I mean, I wonder how you, as a person, go and arrest somebody who has infringed on your copyright and so on. So the government agencies vested with this right protection are just not capable of doing that. And again, if you look at knowledge and ignorance of what intellectual property is and its protection, you find out many of the practitioners are not knowledgeable. They don't even know what it is to protect your right. Some time ago, too, we caught somebody who infringed on the rights of a producer, by mass production of tapes and so on. And to the guy, what he said was, "I'm happy you people publicize your work, getting it to more people." You know, so it's quite unfortunate. It's laughable. People. That's why also I say that the agencies have not sensitized anybody, because the idea of the law is not to catch culprits, but you need to put in the focus of people what they do to infringe on the rights of others. Right now, me as KOK, I've made disclaimers, for instance, of somebody using my Facebook. I don't have a Facebook as Kanayo. Somebody's using it. You know, I've made disclaimers, and I'm now, in fact, I'm the one now who looks like the fake. You know, so sensitization is quite necessary. I even had to go to a Facebook office in Ikoyi, reported. I was reporting myself to them that I'm not. And they have, the guy who is doing it is not being brought to book. It's quite unfortunate that those of us who have taken to this trade since 1992 and beyond have had stories not too palatable to tell. I think that the industry needs intellectual property police to be able, not just the ordinary guys who work in the ministries, to police the works of the creative industry. Intellectual property police is needed for us to be able to, if somebody is caught infringing on the rights of a producer or content creator, it is that agency, not the government agency, that should go ahead and protect the rights and bring the such persons to book. There's a lot to say, but the fact of the matter is, there is a whole lot of playing around the topic of intellectual property protection. And the Nigerian environment is not, I must say, the Nigerian environment is not favorable to content creators, to those who practice in the trade, to those who see it as a means of income or betterment of society and so on. Just like what is going on in America between writers and producers and so on. A huge proportion of it is occurring in Nigeria, and the Nigerian situation is worse because nothing is done to those who violate the rights of others who are content creators. So protection needs to be taken into cognizance. Protection needs to be brought to the fore so that people will know what they do by infringing on the right of others. Now, when you talk about, I don't want to go into the legal aspect of contracts and so on, because people don't even want to sign contracts. Many writers, producers do not wish to go into contracts. And so what you have is a situation where people just take money and then go do their trade. Unfortunately, again, I must bring to the notice of this panel that the practice of, I mean, those who are writers, you know, some of them just want to put something, have the next meal. So you have a situation where somebody could adapt somebody's work, even though it's been trademarked. Somebody has trademarked his work, and somebody goes ahead to shoot it. I realized on one occasion that in Asaba, or is it Enugu, two producers were fighting. And what was it all about? One had trademarked his work, and the other had gotten the script exactly as it is and was shooting it. You know, there was no intervention even when it was reported, and I don't think this is good for the creative industry. So there's more to say, but I think I will rest my case here and still come back and say more. Thank you very much.
All right, thank you very much, Mr. Kanayo Esquire. So some of the issues, or a lot of the issues that you have outlined are things that we've been dealing with for a very long time. And besides the creative industry, these are issues that we're dealing with as a country or as a region. Today, we're talking about the creative industry. When we go to areas such as traditional knowledge, geographical indication, appellations of origin, it's a totally different ballgame altogether. So, but let us hear from Mr. Yusufu from the Patent and Trademark Office before we come back to our panelists. Mr. Yusufu, are you still with us? Mr. Yusufu, are you with us? Mr. Yusufu, can you raise your hand, please? So while we're getting that sorted out, Aisha, you wanted to say something?
I was trying to find Mr. Yusufu because a lot, he represents the policymakers, the government, especially what he tried to communicate through his presentation earlier, the processes. You see, what is playing out here is, especially because of all the issues that have been brought out. So on one hand, you have those who invest their energy, their time, even if these ideas just come to you just when you wake up or in a flash, because yes, some of these ideas, the innovative ideas or creative ideas come to you just like a flash. So some people are gifted with having the brains to create things, to create stories, to write, to create ideas, scientific stuff. So if in order to protect that property, the intellectual property, you have to go through some complex steps and procedures. You have to go through some filing and all the complications, and because especially from the questions that were asked after his presentation, then that is very discouraging. From what the panelists have also brought out, the experiences, the challenges in trying to protect your intellectual property. So we would like to really hear from him, from the NCC, from the Trademark Office, what are there in place, or how have they over time made these processes user-friendly, if I may say, user-friendly. Yes, I think Mr. Yusufu is here. Thank you. Welcome back, sir. Please, this is now, the light is now on you. We need to hear from you. I hope you heard some of the concerns and questions raised. Go ahead and unmute yourself, sir. Mr. Muhammad Yusufu, you can go ahead and unmute yourself. I'm sure he's trying to do that. So as he's trying to do that, I will throw a challenge to those experts in the IT industry. Please, you people need to innovate and create ways that we can simplify all these network connection challenges, to ease our use of all these facilities, the Zoom, so that we will not be having these glitches, even though, well, yes, we are enjoying this based on someone else's intellectual property innovation, creation. So I'm challenging those in the IT industry to please bring ways that we can ease and simplify these.
Please, can I talk briefly while we are waiting for Mohammed?
Okay, please go ahead, Mr. Fulani.
Okay, if I may, just quickly mention that the truth of the matter is that, intellectual property is, and I appreciate and I must salute the work that Nigerian creators and creatives have their contributions to the growth of Nigeria. You know, quite interestingly, I think I was monitoring. There was a movie that came out, Gangs of Lagos, or so, the other day, and the Lagos State government or certain parties in Lagos State, indigenes, took umbrage about the way a certain part of the culture was. Am I audible? Am I audible? Okay, a certain part of the culture was portrayed. You know, and I said to myself, there's a reason why, you know, storytellers tell stories. Storytellers tell stories because, well, when people resonate with stories that are told, especially with movies and things like that, what it means is that they enjoy the stories being told. Now, ordinarily, what a government should do is that one of the roles of government is to step in to encourage the process of storytelling. Now, if you look at certain series and movies, you will see, for example, certain states like Georgia, for example. Mr. Kanayo is in the US. A state like Georgia, Georgia gives tax rebates and provides a tax haven to many creators, especially in the movie industry in Hollywood. Also, you also have a situation where a state like Florida practically gave Disney a rebate that allowed Disney to pretty much create its own continent. Okay, could we give? I think Mr. Yusufu is okay. Yeah. So the point I'm trying to make is that, you know, the government's role is to provide a level playing field, you know, but the ultimate responsibility for protecting one's intellectual property really lies with the owner of that intellectual property or the person who seeks to exploit it, because it's a private right. And, you know, you can't believe, I'm not holding, you know, water for any of the government agencies. We had an interesting town hall with the Registrar of Trademarks, and it was very interesting. He shed some light on some of the innovations that have happened at the registry over the years. You know, but the truth of the matter is that it is the responsibility of the brand owner, you know, to ensure that his or her brand is protected. And I'll give an analogy. A very quick analogy is when you buy a parcel of land, what's the first thing that you do with that parcel of land? You know, we don't call on government to come and secure our land. The first thing you do, if it's not fenced, is to fence it. You know, in law, that's called taking possession. So the first thing you do is to ensure that your parcel of land is fenced, and then you now ensure that the proper documentation. So your transfer agreement, your deeds, and you know, and all of that. So the real responsibility, and there's need for a lot of awareness that even though government plays a big role, so in the gang, using the Gang of Lagos case as an example, what I think the Lagos State government should ordinarily do going forward, rather than banning movies, because when you ban movies, what you do is, especially in this streaming era, you ensure that movie will become a blockbuster. Everybody is going to watch that movie that was banned. You know, so what the government should do is to engage the creative community before the stories are told and tell them, okay, we're going to give you these incentives to encourage that community. And then naturally what tends to happen is that before these stories are told, there's some back and forth, you know, and so on. Think of Things Fall Apart. About 10 or so years ago, 50 Cent, or a little more than 10 years ago, he produced a movie titled Things Fall Apart. You know, and the late Chino Achebe of blessed memory took umbrage, and he famously said in a public statement that before you were born, I had written that my book, Things Fall Apart. You know, but he engaged with there are no records, and that's one of the beauties of mediation. The engagement was pretty much behind closed doors. You know, but what we know is that a few weeks later, 50 Cent changed the name of his film to All Things Fall Apart. You know, and that's ADR, even though whether it was structured or unstructured is a different issue entirely. But the idea is that the responsibility for protecting that work lies with the creator of the work first. You know, and then government does have its responsibility, but its responsibility is shown from a different phase or a different aspect. Thank you.
Hello, can you hear me?
Mr. Yusufu, it's good to have you back. Just before you respond, I'd like to remind you of some of the key points that we are considering. Mr. Kanayo had hooked at a project I started 14 years ago, Idea Police. Interestingly, with Oga Yauri as my mentor then, when we started Idea Police. But then the essence was actually intellectual property awareness. We were discussing how to have IP education as a curriculum connection to in our schools. So, but I'll just have you respond. He talked about the fact that government agencies are a bit tardy in their role towards the protection of creators, and not much is being done to protect the rights of creators. And then he suggested perhaps the possibility of having a special police unit for intellectual property. So let's get your view on that. What do you have on ground? What have you done? What are the possibilities? Besides, of course, within the, it's two parts right now. Before there's creation, before there's infringement, what can be done to ensure or to avert these kinds of issues? Over to you, Mr. Yusufu.
Thank you for the opportunity.
Mr. Yusufu,
are you hearing me?
Hear us?
Yes, I can hear you. Are you hearing me? What's the problem?
Yes, yes, we can hear you.
Can you hear me?
Yes, please go ahead. We can hear you. Go ahead.
Okay. Honestly, it is a very, very exciting workshop. And largely, I want to first commend Laura for her presentation, Mr. Folari for also throwing some highlights on our practices, particularly from the trademark registry here, and also Binta in particular. I share her concern for the unfortunate situation she found herself when she said she even had the opportunity of even coming to the trademark registry here. But all the same, just like I started when I was presenting my paper, I did say the registrar of trademark himself is very much around. And as a matter of fact, he's loud and clear hearing all the concerns being raised. So I want to just give him the opportunity now so that maybe he can respond to some of this, particularly that of Kanayo and Kayode. Thank you.
Hello, and thank you very much for giving me the floor and the opportunity to speak. Hello? Idea Police, you can hear me?
I can hear you, sir.
Okay. I think various speakers have mentioned the issue of IP rights being a private right, but that does not also stop government from playing its role as a key driver of the intellectual property system in the country. And to that effect, we as a registry in our 2023 strategic direction, we have evolved three key areas of attention. One is to improve administrative processes, including our examination processes, and to fast track particularly national registration. Number two, to also improve our opposition and appeal processes. This is to ensure effective enforcement of rights and quick dispensation of those, that aspect, because we have many. Each time we publish journal, and you will agree with me that of recent, our publication has changed from the ones in 2 or 3 years that somebody has mentioned earlier to at least 9 to 10 journals in a year, and we have been consistent with that, and I believe we will continue with that pace. Then the third pillar is improving our collaborative arrangement with ministries, departments, and agencies of government, and particularly IP organizations like this engagement that we're having with you. So these are pillars that we intended to build a formidable front in order to engage and to enhance the administration and enforcement of trademark rights in Nigeria. Mr. Folarin has mentioned the issue of being a private right, you need to be up and doing in protecting your right. Yes, it's true. But at the same time, the Trademark Registry has created a desk. And in this strategic plan, we have engaged and brought on the table the Nigerian Customs, the Nigerian Police, the Standards Organization of Nigeria, and the National Agency for Food, Drug Administration and Control. If you have any issue concerning brand right, trademark right, that has to do with enforcement, and there is an issue that you feel you need our assistance, you simply write to us. And if it is related to customs, what we do is to write customs for goods coming from outside the Nigerian borders, and we complain and support your complaints to us. And we have many cases where the customs authorities have stopped shipments of so many goods at the border. If it is internally, we also use the police, and we have several cases of enforcement cases that are successful cases we can cite between the Trademark Registry and the Nigerian police, including certain raids and detention of some goods, and investigations are still going on. Now, since our signing of Memorandum of Understanding between the Trademark Registry and the National Agency for Food, Drug Administration and Control, there is no application for food or drug or cosmetics that goes to NAFDAC without request for evidence of trademark registration. This has again established that strong bond of relationship between what goes on at NAFDAC and its relation with the Trademark Registry, and also reduce the number of people who are using other people's intellectual property in order to obtain certification for it. And the same thing with the Standard Organization of Nigeria. That is on the one hand. I told you part of the second pillar of our strategic plan has also been enforcement, uplifting, upgrading, and enhancing our internal opposition and appeal panel. And that opposition section has been so improved with additional panels that sit and hear cases. And all of you are aware recently of the Domitila case, which is a matter that has been handled by this registry, and which was decided also by this registry. So these are some of the ways that we have taken steps, proactive steps, to assist creators in protecting their intellectual property rights. I want to affirm that trademark rights is crucial to innovators, to creators, to businesses, because it does not only identify the source of a product, it distinguishes even competing products, it gives testimony to the quality of the product. It sells itself because it is an advertisement instrument. When you go into any shop, any market, you go direct to the product that you choose because of that name that it's attached to it. There are so many advantages that goes with trademark rights. And a question has been asked, is it possible to have multiple intellectual property rights in a product? Yes. Let's take the Domitila matter. The Domitila itself is a film, and the name Domitila is a mark. So you can see there is copyright and there is a trademark. In some instances, you may have an invention which is protected by a patent. You may have a brand name or a trademark which is protected by a trademark, a sign symbol protected by trademark, and you have a copyright also in a product. So it is possible to have from one individual several intellectual property rights in a particular product. I thank you very much for giving us the opportunity to speak, and we look forward to further engagement, and we are ready to answer any specific questions that you may have. Thank you very much.
Thank you, the registrar.
Okay, thank you very much. Thank you, Dr. Yauri, my very own big boss there. And then, of course, Mr. Mohammed Yusuf, thank you so much for the contributions and explanations so far. At this point, I think we've done a good job looking at what the issues are. So we've come to that point where we need to proffer more solutions to say, what will the recommendations for the communique be for this event? From the interactions we've had so far, it's very clear that we need to have discussions like this more often. And also, this conversation is only a primer to the physical one, which will give us more room to have much more conversation. I also want to announce that the National Nigeria Chamber of Commerce Dispute Resolution Center will have a booth at the forthcoming Abuja International Trade Fair. So people who want to make inquiries and have physical contact can either come to the office at the headquarters of the Abuja Chamber of Commerce and Industry or join us during the trade fair in September. That said, we have word from Ali Nuhu, the veteran actor. He tried to join us but could not. He's currently on set right now. He sent his apologies. And if we're able to have him join us before we close, then we will have him say a few words. So, Mr. Fulaiwa, are you going to lead the way? What will be your recommendations for the communique? Kindly unmute yourself.
Mr. Collins has been trying to speak. He's been muted. Maybe he wants to say something before Mr. Fulaiwa goes on.
Okay.
Okay, that's great. Mr. Collins.
Admin, can you please enable Mr. Collins to unmute?
Okay. Yes, I'm on mute. I'm
Okay,
on
great.
now. Thank you.
Okay,
Thank you
great.
so much.
Right.
Sorry, I just want to address some issues, particularly some of them that has been raised by our own very dear veteran actor, Kanayo Kanayo. So the Copyright Commission, as you may be aware, is it started with the responsibility for enforcement of copyright in Nigeria, for the enforcement and prosecution of copyright in Nigeria. And over the last few years, we have actually tried to do our best within the resources available to us. For instance, in the last couple of years, we have been able to carry out over 374 anti-piracy operations in some designated areas in Nigeria. We have also been able to remove from various market and piracy locations goods, pirated goods, books, of course, mostly books that are worth close to 10 billion naira. And we have also, working with the Nigeria Customs Service, been able to seize about 30 containers of containers containing pirated copyright works, mostly books. I mean, the records are there, even in the customs and all of that. They can also testify to that. And of course, as we speak, some people are still serving jail terms in Nigeria as a result of convictions secured by the Nigerian Copyright Commission over the years. In fact, we have secured more than 60 convictions in the last 8 years or thereabout. And so these records are there, and we are willing to share these records with anybody. And of course,
sorry, Mr. Collins,
yes.
just a minute, Mr. Collins. Yeah.
Yes.
Please kindly hold your thoughts. What is the ADR connection in all of this? What is how have you used the agency of ADR to handle some of these cases?
Yeah, for instance, there was a time the then CUSON, Copyright Society of Nigeria, had the start times StarTimes declared dispute, against COSON, and we stepped in under our dispute resolution panel, and that dispute was settled. It was amicably settled. And we have also had situations whereby the Hotel Owners Association of Abuja Hotel Owners Association, we are having also disputes that has to do with royalty payment with COSON also. The commission stepped in also, that dispute was also handled. And apart from those organized ones, all over our 14 states across the country, there's been one form of dispute settlement or the other without having to go to court, that was facilitated by the commission. We always encourage, right owners whose work are being violated, to kind of find a way to have discussions, through their lawyers and through the lawyers of the infringer, to have discussion with a view to find a solution to settle their dispute without having to go to court. Of course, we had so a lot of dispute has also been settled that way, whereby the infringer and we're able to bring the infringer and the right owner together, and through their lawyers, they were able to reach amicable agreements. And of course, the commission usually is not directly involved in that one. We just bring them together and they talk and they agree on terms of their settlement. So those are some of the things we are doing. And now that we have, and now the commission is intending to, step further on this, because like I said, when I was talking, the dispute resolution panel, the dispute resolution provision has been, added in the CMO regulation, which now makes it, encourages them to, as much as possible, resort to dispute resolution as a first line of, action before any other thing. Thank you.
Okay, great. You have made quite some very interesting statements and taken useful positions. I would hope that going forward, the NCC and the chamber movement, especially the Abuja Chamber of Commerce and Industry, will find a way to do much more work, especially as it affects the trade-related intellectual property disputes. Of course, we are very excited that the NCCDRC is doing this. So, but please expect to hear more from us, and hopefully we'll take these collaborations further. Mr. Kolariwon.
And just to add, just vital information I missed. In 2021, our own dear RMD was able to get close to 30 million naira out of ADR that was facilitated by the commission. Thought I should add that also.
I'm sure that is good news for Kanayo. And perhaps, but then you did not talk about the Facebook. Is there anything you're doing to support Kanayo to be Kanayo on Facebook and not have an impostor be KOK on Facebook?
Yeah, if under the new Copyright Act now, the Copyright Act 2022, it has made a robust provision to combat online copyright infringement. And we now have a unit that is specifically dedicated to the online infringement. So if we have such if we get such complaint, from him, we take appropriate action. I can assure you about that. Of course, I wish to also report that the commission now has anti-piracy hotlines, where we try to address cases of infringement. Once it is reported to us, we take action. If there can permission, I would like to just mention the anti-piracy hotline, for the benefit of some of the creators that are on this program. The anti-piracy hotline, we have two of them, have 090 19 32 Let me take it again. 090 190.
I think you're breaking, Mr. Collins. You're breaking. Can you go over that number again? 090
190.
Okay.
03.
Okay.
200.
Okay, that is 090 190 03200. Is that correct?
Yes. Yes.
Okay, the second one.
The second one, 090 19 00
Okay.
32
Okay.
01.
Okay,
And of course,
fantastic.
yes, for telephone, if we call us, is a 24-hour hotline, for dedicated for a reportage of copyright infringements. And the commission will be happy to take appropriate action. And of course, our website is, our email address is info@copyright.gov.ng. So the Copyright Commission is willing to, collaborate with, stakeholders, to ensure that infringement is, copyright piracy is drastically reduced in the country. And anytime you call on us, we are very willing to, collaborate to see what we can do, to better the lot of the creative industry in Nigeria. Thank you.
Okay. All right. Thank you very much, Mr. Collins Nweke, for that very useful information that you have shared with us. Top of it is the fact that, as you said in your words, our very own RMD has been able to get up to 30 million in compensation, yes, through your ADR. Yeah, so as soon as Mr. Kanaya arrives in Nigeria, I'm sure that he can begin to make moves to perhaps have such and such amount in his own possession. Olaiwo.
Thank you very much. And thank you to
Mr.
everyone.
Olaiwo.
Yes.
Okay.
Yes, I'll say thank you very much. Thanks to everyone for staying, for being part of the conversation, and a big thank you to the NCC/DRC for putting this very interesting conversation together. I think in conclusion, I would say that the pace at which new technology or new media, is evolving really has challenged and has stretched our laws. And in fact, it's even stretching our understanding of intellectual property, or the limits and the scope of intellectual property today. I read some numbers from Statista last year, and it showed that the creator economy, I think the creator economy generated more than $50 billion, across different countries, but particularly, I think it had to do with Nigeria, and what that says for me, when you go online, and you see people creating media, user-generated content, there's a huge potential, for commerce, a huge potential for revenue generation. And it also means that there's a huge potential for disputes as well, and especially with new media, ADR presents perhaps the best, if you may, value proposition as to dispute resolution that you have today. It's fast, it's cheaper, it's confidential, and then it's, most importantly, it's driven by the parties, and it helps the parties achieve a win-win. So it retains the relationships that exist between the parties, and one cannot overemphasize this. I think one way, there was something Laura said about the creative industry being creative with the dispute resolution process. And I see that one way that some creators have tried to address this issue, some platforms, is to address dispute resolution as a customer service issue. But there was some research we conducted, I think about 2 years ago. We asked people, what are the top ways by which you resolve your disputes arising from online transactions? And the first three things, the top 3 items, the first thing was, I think the highest voted item was, people said, we leave it to God. So we leave it to God. The second one was, we call the police. you know, and then the third one had to do with, you know, briefing a lawyer and going to court, which was way down the line, you know, after God and police. So I think when it comes to new media, especially, and intellectual property, the best way to resolve disputes is through alternative dispute resolution, particularly mediation and perhaps conciliation and arbitration. So we'll be very happy. I'm on LinkedIn, I'm on Twitter, Instagram, and the Institute is also on all these platforms. We really appreciate the NCC DRC for driving this, what I believe will be is the first of several other conversations. So thank you very much for having me.
Okay, so Mr. Flariwa, you have not made your recommendations.
Oh,
yes. So where we are right now is recommendations for the communique. You know, yes. So if you'd like to give us a few recommendations for the communique.
Okay, I think my first recommendation would be that state institutions, especially state institutions that are responsible for protecting intellectual property rights, should, as a matter of course, make rules or direct parties to first embrace ADR. And I say this because already it's done. If we look at the rules of procedure, the rules of civil procedure for most courts, we find that there are rules that direct parties to, or that encourage parties to embrace alternative dispute resolution, so mediation and so on. So I would say that first recommendation is that there should be a very deliberate effort on the part of state actors. I know Oga Yaori mentioned that, yes, the state does have its role to play. That's the registrar of trademarks. And so I agree with that. And first is that state actors should, as much as possible, direct parties to embrace ADR. And this is as far as it only involves
Mr. Flariwa, are you there? Okay, so while we wait for Mr. Flariwa to come back to us. Okay.
ADR. Are we together? Hello?
Hello, can you hear us, Mr. Flariwa?
Yes, I can hear you.
We lost about 45 seconds of your content. Can you backtrack a little bit? Yes. Okay, I think we're having some technology challenges. So, Aisha, can you all right, Ms. Binta, are you still with us?
My sincere apologies. You know, we're still battling with technology. You know, we're still battling with technology. So I was saying that state actors, number one, should, as a first port of call, should direct parties where disputes are reported, should encourage parties to embrace ADR. And that should, as perhaps, if possible, should be written into their rules of procedure or regulations. I think second recommendation will be for state governments to, as a rule of thumb, you know, to encourage the creative industry by initiating policies that, you know, make it cheaper and easier to create. And what this does is that it actually removes, or it reduces the possibility or probability of certain types of disputes. I referenced the Gangs of Lagos incident because there was a huge row between the Lagos state government and the producers of the Gang of Lagos movie. But then when it comes, video regulation and censorship is not a state issue, it's a federal issue. And there's a federal agency that is, you know, responsible for that. But the problem that the Lagos state government had was perhaps the depiction and my mother is from Lagos, I should also say, the depiction of certain cultural aspects of certain Lagos institutions. But then I believe that issue could have been resolved at the writing stage if the Lagos State government had taken a more proactive attitude or approach towards engaging with creators. So I think that would be my second and final recommendation, arising from this conversation.
All right. So Aisha, while we wait for Binta, I think Binta has left. I can't find her anymore. I'm still also looking for KOK. But while we wait to see them, Aisha, can you make your comments?
Yeah, if you recall, Binta did inform us that she was also attending another meeting. So probably not, she may not be back.
Okay, so I see that KOK is still with us. Mr. KOK, can you give us your final thoughts?
Yes, I hope he's very awake now.
Mr. Kanaya, are you still with us?
Mr. Kanayo Esquire, any final thoughts?
Yes, thank you.
Yes, we would like to get your recommendations for the communique. Yes.
Yeah, Aisha, once again, thanks for inviting me to this panel. I feel honored. Let me touch on one thing that Collins Nweke said. Collins, I thank you very much for bringing us to speed of what your agency is doing. But I think we need to borrow from what the National Drug Law Enforcement Agency does whenever it arrests people with drugs. It's immediately publicized. And I think when it's publicized, it acts as a deterrent to others who might want to take the same route. Now, you talked about securing convictions. How much has it been brought to the public domain of the convictions you have secured over the years? Yeah, we commend you for what you're doing, but we need to bring such things to the fore that will serve as a deterrent to those who violate intellectual property. I also have a little disagreement with, I think my brother Aluko or somebody who was talking about what you do when you purchase a land and what you should do also when you create a content. I see it more of not being at the same par with trying to register your trademark and then just as you would do fencing a property. I think they stand worlds apart because it's intellectual work, which I mean, a land is fixed. Intellectual work is not fixed in any particular location. So I may have some disagreement with that. Be that as it may, enforcement is critical to intellectual property protection all over the world. We must go to the extent that people will see it as depriving others of their sweat, which I have been part of for over 30-something years. People must be brought to book to know that what they're doing is depriving people of their livelihood. Maybe I've taken the 2 numbers of the hotlines to when I come back to Lagos, because what this guy does is, if as I'm speaking now, no, I'm still in bed, I could show you my picture. If I take a picture of myself in the United States now and post it and say, still asleep, good luck Nigerians who are awake, this guy will copy and paste on his page as Kanayo. So you think it's me. I'm not really too bothered, but he defrauds Nigerians through that process, acting like me. So anything I do, he just copies and puts on his page. And one of the most annoying part of it is that among the disclaimers I have made, People still think that me, KOK, I'm the fake one. Because he promises them, just like he says he's going to give a deep freezer of 300,000, and he's asking you to send 15,000 for transportation. And you send the 15,000. I mean, people, I don't know whether people are complacent or daft and so on. So this is really, really sad. But as we way forward, I still stand by my words that intellectual property protection is not a job for the regular police. It's not a job for the regular police. I still call for the intellectual police protection squad to drive this protection we're talking about. We're talking about people who understand the job, just like the Alukos have spoken on this program, Collins Walker has spoken. People who have an idea. You cannot have a medical doctor. You cannot have even a lawyer who has no interest in the entertainment industry, being a legislative representative of a constituent in the National Assembly. You must understudy what content is. You must know how the entertainment industry operates. So it's not a job for the regular police. And that would be my last word. It's a job for a special anti-squad that whenever a violation, a breach happens, they move in. They are not people who can be bribed or compromised. They are people who understand the trade and understand that people are being deprived of their sweat every day. I feel for my colleagues. People have left the entertainment industry because they cannot produce a second one from what they did before. Not because they didn't tell good stories, but because they couldn't make their money back. You know, and the people who are doing this, the infringers, are not brought to book. And that's a very crazy one. You can't do that. I mean, I'm not holding brief for the United States or United Kingdom, but we need more enforcement and maybe a review of the legislations guiding this intellectual property protection. Thank you very much, Aisha, and other panelists.
Thank you very much, Mr. Kanayo Esquire. We sincerely sympathize with you for having this self-appointed alter ego, celebrity stalker, as it were. I do hope that perhaps Mr. Collins and other agencies of government will be able to, again, this is an issue with big tech. So I do not know if Mr. Collins, I think your RMD reference obviously was not with a tech giant. If it is, you can let us know. But I think this has to do with cybercrime, as Mr. Dego Kikayode is posting in the chat box, and he's saying it's very prosecutable. So again, Mr. Kanayo is now a lawyer. So this is a very interesting case. And I think how it ends will play a big role in IP infringement awareness. It will become one of those leading cases that we can use when we do these curriculum connections with school pupils and students. So last words from you, Mr. Collins Mweke, before we get to wrap up. 1 minute.
Okay, yeah.
Mr. Collins.
So, yes. So, can you hear me? Can you hear me? Hello?
Yes, I can hear you, yes.
Okay, so ADR is very important issue. I mean, in this, in this era of, especially of, high level of infringement. But I would like to say that, there should be inclusion of dispute resolution clause in copyright-related contractual agreements, so that it will be clear from the outset that, the parties will explore, dispute resolution in case of disagreement. Of course, ADR should also be clearly, we should begin to explore ADR route promote that ADR will be taken as the first line of action in case of copyright infringement. So having said that, I will also want to add that copyright owners need to monitor their copyright assets online and offline, and they should also try to obtain evidence of infringement where there is infringement. And if it is online, if it is possible, they can screenshot the site, that is hosting that infringing content. Then they can send a cease and desist letter, to the infringer, and also send a takedown notice to the ISP, the ISP that is hosting that particular site that is infringing the work. You should be able to send a cease and desist, send a takedown notice to them, because it's now under this our law that once there's an online infringement, you should be able, the owner of the work, you should be able to send the cease and desist letter to the ISP. And after that, if the ISP do not take expeditious action to take it down, the ISP can be held, liable, and the commission can move in to see what, how to deal with that ISP. And of course,
sorry, Mr. Collins, just so that we're clearer on this, do you have any decided cases or references? Are there incidents where you've done this, maybe with a Microsoft or a Google or a Facebook or Instagram? Do you have any examples?
Yeah, right now, the cases we have, because it's only when these things are reported to us, that we step in. But I'm aware that we are working with the International Federation of Phonographic Industries, the umbrella body for music, across the world, to carry out online investigation concerning one infringing rights. We are still on it. We are still doing the investigation right now, working with IFPI.
Okay, great. Yeah, so perhaps the Kanayo's case will, form one of the, as lawyers say, locus classicus. Aisha, is that correct?
Emeka, don't go and say the one that you don't know.
Yeah. That's why I'm asking you now.
Okay.
When I finish,
don't go and be speaking lawyers' language.
No, I'm behind Kanayo, so don't worry about that.
We'll be happy to welcome you on board.
We latecomers welcome.
Yeah. You'll be welcome, because I became a lawyer at 58. So it's not late.
See what I'm saying? You see what I'm saying? So, but
locus classicus is for decided cases.
Decided cases. That's actually what I'm talking about.
My own has not been intervened by Collins Maker and his group.
Yes, that's actually what I'm talking about, because
he wants it to be decided so that it becomes locus classicus.
Yes, Adegoke said it's very prosecutable. So perhaps when you take it to the highest level, the Supreme Court, it can become. But having said all of that, I think it's been a very useful conversation. I'd like to thank everybody who participated. Godwin Ekbo, I see you. Samin Ibrahim Haruna, thank you. Folarinwa, I'd like to thank you especially for the work you did in the chat bar. You saved us a lot of time, and then of course, our presenters, Mr. Sadiq Yusufu from the Trademarks and Patent Office, Basil Udota Esquire, who wasn't able to be here, Laura Lakija, we're very grateful. And then, of course, the panelists, Mr. Collins, thank you so much. It's been useful having listened to your presentations. Kanayo, of course, sorry for, having you talk to us from using part of your sleep time. Of course, Alinu, who is on set, he's not able to join us. And of course, Mr. Folarinwa, I'd like to thank you very much. And also, I'd like to say that I have instructions from the NCC DRC that there will be certificate of participation for this workshop at the cost of 5,000 Naira only. And that those who are interested can send an email to nccdrc@accinigeria.com. I can take that again, nccdrc@accinigeria.com. And then also for more information about the center, participants can visit www.nccdrc.org. nccdrc.org. With that said, I'd like to hand over to Aisha to give a vote of thanks before we call it, bring it to a close.
Emeka, which vote of thanks after you have already thanked everybody? But then, thank you so much for making mine easier, because honestly, we cannot thank you enough. He can thank you and I can thank you too. It is obvious all of us are busy. We know that, well, as it is, as we are experiencing, some of you had to show face and then jump back to other activities or meetings. Some of you couldn't make it. So especially for the speakers and panelists who took out time to research, to think, to sort through their wealth of experience, to bring to us, to share with us here. We cannot appreciate you enough. We sincerely appreciate you. Thank you so much. And then you have definitely shown us that there's so much that we need to learn, and there's so much that needs to be done on all parts, on the part of the policy makers and regulators, on the part of those of us who enjoy creative work, to also help in doing what we need to do, the right thing when we are using the creative work, movies, the literally work. I saw from the comments bar, a sister of mine, Isioma, saying that when I was listing examples, I didn't mention books, but definitely books are number one, because people literally pour out what is in their heads. So it's, all intellectual property are originally from someone's intellect. So those of us who make use of it also have a duty to also protect it and use it right. Those of us who are in the position, who are blessed with the creative minds, also need to remember that just as you invest resources to purchase something like a landed property or an item, you also need to put efforts to do the right thing to protect and ensure that you keep that property, the intellectual property that you have created, well guarded, because it is not easy. Even if the idea came in just as you are waking up, like our big brother Kanayo just woke up from sleep and he just poured all these, because he has a wealth of experience. He can just think of something real new and beneficial for us now. So it needs to be well taken care of. Just like you will buy the pouch for your phones and screen guard because you know you spent a lot on them, the same with every other property that is of value. So all of us have a duty, and there's a lot of work to be done. You have given us a lot today. We have learned a lot. The participants, thank you so much for all that you have done in the chat box. A lot of you have made some contributions and observations. Yes, we have a lot of work to do. And just like the chairman of our center, the NCC-DRC, said earlier, the NCC-DRC will go the extra mile to see that the interventions and contributions and recommendations that have been made here succeed. We will follow them through. We will do the best that we can to provide the assistance or the necessary push from our own end the way we can to help these things succeed. And Emeka has mentioned earlier that as much as you have enjoyed this workshop, this is like just the tip of the iceberg. We plan to organize another one, which we hope to be physical, because, well, it is difficult to bring all of you together in one room. But we know that bringing you all together in one room would create the better effect that we would need in terms of all the recommendations being successful, in terms of us taking the industry to the next level. we have reached the stage where, yes, we are able to compare ourselves with the US and the UK and other jurisdictions, but we want to get to a stage where we will say, okay, yes, we are where we belong in terms of the value of our creativity and all the measures that we put in place. So thank you very much. And do keep an eye on the space. You have been informed of our website. And then of course, I want to now use the word that I just learned today, the new media. I usually use social media as the layperson in that respect, but the new media, keep an eye there. We are on all the platforms. We'll keep you abreast of what we do and all that would benefit you. And of course, we will welcome any contribution from your own end to help us also keep doing what we're doing and making the best of it. Thank you very much. I can see a hand up. I don't know if we still have time to entertain any comment. Emeka, I will yield to you to guide us. If we do not, of course, you have all our contact details. Any other suggestions, questions, inquiries can come to us through our contact information that has been given. Thank you so much for taking our time to be with us.
Okay. Thank you very much, Aisha. While you were speaking, we had a few comments in the chat box. Our very own former Attorney General of the Federation, Prince Adetokunbo Kayode SAN, he joined us. Thank you, sir, for joining us. And also there is a question by the Oracle himself. At the beginning of this conversation, I did send a slight warning for people to hold tight, to their chairs because Kanayo is in the room. So, but Kanayo is asking, why are we being charged for the certificates? Aisha, you may want to address that before we start disappearing, please.
Okay, sir, because the certificate is also a property. So much as they have enjoyed, everybody has enjoyed the valuable contributions for free. But then, of course, because it's a property, you have to pay a token. 5,000 is just a token, especially to show the value of what they are getting. Yes, sir. So this is the long and short of the story. But then, yes, it is important. Anytime we know that we are acquiring any property, if we get it for free, well, most of the time we value it less. But anything that has value has to come with a price. The certificate has value, sir. It has to be paid for.
Okay, thank you very much, Aisha. In any case, it's voluntary. It's not compulsory that you get the certificate. It's for those who are interested in getting the certificate. So that said, I'd like to thank our partners and sponsors, ICMC, IPI. Thank you so much, Copyright Commission. Thank you, Collins, for being here this long with us. Thank you to the management of the Abuja Chamber of Commerce and Industry, and then, of course, the National Chamber of Commerce Dispute Resolution Center, Chief Emeka Obegolu, SAN, Madam Aisha, all our presenters, Laura Lakija, Sadiq Yusufu, Mr. John Asian, and then, of course, myself. So thank you very much, everyone. And we hope to see you all during the physical version. I would say from here, to have a good afternoon and enjoy the rest of your day. Thank you very much. And thank you for Lariwa. Thank you so much. I hope to see you again. Thank you, sir. Thank you very much. All right. Yes, Mr. Samuel. Thank you, everybody. Thank you so much.